Okay, so the parties had an 8-year-old son, and the mother had been diagnosed with cancer. And this is the key. She was a proponent of homeopathic, holistic, and natural remedies and therapies. Now, imagine the judiciary and what they generally think of such things and people who believe in that. What do they think about Gwyneth Paltrow? Yeah. Well, okay. So the father deposed that the child told him that the mother made the child urinate in a jar and that she then put some of the urine in a smoothie for him to drink. The father said he found jars of urine in the bathroom. The father also alleged that the mother does not believe in COVID-19 and is an anti-masker and an anti-vaxxer. Okay, you can imagine where the master's head is going. Yeah, and it goes there. So the mother deposed that she never used urine therapy on the child, and she never puts urine in his food or drinks. She said she gave the child a jar to pee in order to monitor his lymphatic system to check if his kidneys were filtering. Why? Because, and this is a complaint by some parents, the father was primarily feeding the child a diet of high fat, high sugar, and high salt, leading to her to be concerned about the child's health. The mother said, look, he pees in a jar. I shake it around for a while, let the sediment go down, and I check, all good. And then she dumps in the toilet. That's what she says she does. Well, Master Robertson found that both parties exaggerated in regards of the wrongdoing of the other. Now, because this is all done by affidavits, right? So there's nobody giving oral testimony here. But then Master Robertson decided, I believe the father's evidence more because I found it more balanced and centered on the child, while the mother was more focused on defending her health beliefs and minimizing their effects on the child. The mother also did a lot of stuff on social media that the master didn't like and the father didn't like. And she, posted things and I'll tell you, well, here we go. He notes a number of factors that he says undermines the mother's credibility, including that there was independent evidence that was contrary to her evidence. For example, the child's family doctor had reported that the child said to the family doctor that there was urine being put in his food. Now, in the course of his reasons for judgment, Master Robertson does note that the child recants at various points and says, no, that didn't happen. The mother's evidence in respect of her beliefs as to the health benefits of urine therapy are rife with opinions and unproven therapies. I mean, this is probably the language that would come up when a parent is opposed to the COVID-19 vaccine if it went to court. And this is an interesting one for feminine. Her use of extreme language and adjectives such as gaslighting, narcissistic abuse, terrorizing, and dictatorship suggest exaggeration. And Master Robertson noted there's often no factual description to support such adjectives. I'm going to clean these slides up. My apologies. How many times do we hear our clients talk about, their ex being gaslighting them, being narcissists, terrorizing them, harassing them, and so forth? And here's the judge is like, this stuff isn't real, right? And it's hard sometimes because, of course, when your client sort of describes what's going on and the other side, in this case, the father, is just like, no, that I don't do any of that. The judge decides, well, I believe them generally. I believe the father more generally in many things. So therefore, this kind of conduct, I don't believe happens, right? That's very clear in here that the master has an impression of the mom based on the affidavits. And then the master points to the mother's friends' affidavits, basically calling them self-serving. And it doesn't appear they were aware of the allegations being made against either party. That is, for example, they weren't told that the mom apparently, puts urine in the kids' foods. And then the affidavits were ripe with opinions and superlatives, like she's the best mom ever, which really should never go on an affidavit. And I know all of you know that. So Master Robertson concluded that the mother was acting in such a way that her judgment, particularly as to health matters and the risk of urine therapy, constituted exceptional circumstances to warrant supervised parenting time. Whoa. If you've heard me before talk about supervised time, you know how sort of narrow it's supposed to be, the grounds in which, it's supposed to not be used except sort of close to last resort kind of thing. Anyway, But apparently the mother who had been parenting this child was a risk to her child. The funny thing is, okay, how does this work? Then the court orders that the mom would have parenting time from here, Sunday at 6 to Wednesday at 6. Sunday, Monday, Tuesday, Wednesday, 3 full days, supervised by a professional supervisor or a third party agreed to by the parties. So basically, and the master doesn't say who's paying for a professional supervisor, but they're supposed to find somebody who for 72 hours is going to hang out with the mom and kid, including sleepovers, and have to probably stay awake because the only way you can supervise is if you're awake, right? So it's an interesting case. I'm interested because I don't know if you have clients who, I do have some clients who are, they either don't believe in having COVID vaccine shots or perhaps vaccinations in general, and certainly not for their children, and certainly not necessarily ever, but sometimes it's until there's more research, right, on the side effects and the potential damages that could cause people or children from these vaccines. And I've had to tell clients is like, I respect your position, but you have to know if it goes to court and your ex makes an issue of it, and it's going to, and you not agreeing to either vaccinate yourself or your children if they are able to be vaccinated, and it causes the children, for example, not to be able to go to school or participate in activities, or it could put their health at risk, I can tell you where the court will go. The court will side with the parent who will do those things, because just like general vaccines for measles and so forth, you're not going to find a judge being convinced that these are not appropriate medical interventions for children. So, some of my clients have very strong beliefs about things, and I respect that. But I do have to tell them how it could play out in court if they continue with their position. And like many people, like healthcare workers now, and so, who have their mandatory vaccination, they have to make those decisions in their best interest. So anyway, moving on to some parenting arrangements. This is a case called Aujla and Gill by Madam Justice Gill, Supreme Court. There are 4 kids, and they resided with the mom since separation primarily. And part of the separation arose from the father's alcohol dependency. But when they separated, which was 2015, but for about the last 3 years, so leading up to 2021, he's been sober. Now, the parents don't agree on a number of things, including homeschooling. The mother, who had primary care, was homeschooling the kids, and the father didn't want that to be the case. After he became sober, so a few years ago, he was able to have parenting time with the children, but it was supervised by the mom. Then at the start of COVID-19, as you know, it screws up a lot of the parenting plans that people had in place. And that was the case here, where the father experienced difficulties exercising parenting time, not only because of the pandemic, but also then the children started to become distant from him. And the mother, he said, was not actively encouraging the children to cooperate in coming to him. Now, they're not little kids. They're sort of that 7 to 13 range. So, there's some closer to the tweenie age. So then what happened also sometime in late 2020, under cover of the pandemic and wearing their masks, the mom moved with the kids away from the Lower Mainland to Kamloops. Kamloops is lovely, by the way. And then the court, so Madam Justice Gill actually presided over a trial that went from like November to May. And in November, sort of as the first set of dates ended in trial, she ordered a Section 211 report. And I think in January, when they came back, she ordered, you'll see, some other unsupervised parenting time. So there was a Section 211 report done by Dr. Elterman, who found early stages of parental alienation. He also concluded that the kids were doing really badly at school, and they had problems with their motor skills, and they weren't being treated for that. They spent only an hour a day in school and didn't have a structured education plan. And so he didn't recommend homeschooling. Dr. Elterman also recommended that there was no risk to the kids from the father, and that the parent should move towards a shared parenting regime. So what happened was, as I said, the trial sort of like had a number of days. And so in the middle of the trial, Madam Justice Shergill made an order for unsupervised parenting time for the father. And she also, this is in September, also ordered the mother to return to the Lower Mainland with the children. So and she had till, I think, January of 2021 to do so. So sorry, the trial didn't start in November, it started before. Anyway, the court found the father to be credible and reliable as a witness, and the mother not to be. Madam Justice Shergill found the mom to be woefully unequipped to homeschool the kids, and that her motives were motivated, her moves to different places were motivated by her desire not to co-parent with the father. So rather than co-parent with him, she fled. The court gave little weight to the children's expressed desire not to see their father because of the negative influence of the mother in shaping their opinions of the father. Madam Justice Shergill found that the mother's conduct did not reach the level of parental alienation, but she was on the path towards it. And she found that the children's emotional well-being was better served by increasing their time with their dad with the goal of reaching an equal shared parenting. On the issue of education and health, the judge found that the father was better equipped to meet the children's needs and awarded the father final say in decision-making on those matters. The court and the father wanted conduct orders against the mom, which she consented to, which included things like she was to encourage the children to have a good relationship with their father and that she not talk negatively about the father and a few other things. As judges are very prescient, Madam Justice Shergill was expecting that things could go off the rails, and so she seized herself in the matter for 1 year. Okay, that's that. I guess that's a good case if you want to. I mean, it's a case where obviously there's if you want to sort of see sort of. It's not the same, obviously, every judge, facts are all different, but sort of like parameters around when a court might flip the parenting regime and flip the decision-making. And this is a case where the court's like, yep, we either have to intervene. So the court's being quite interventionist here in doing so, in that the children have been with a mom all the time and is basically flipping it. So even though the court doesn't find alienation, the remedy is almost like they did find alienation. They found enough of the mom having done something, the judge did, that warranted basically flipping the power towards the father.